We have receivership, and it refers to a situation where a creditor, and when we say usually secured by debenture, we had talked about floating charges and fixed charges. This one is where that creditor has an asset attached to the funds he has availed to the company. When they realize that the company is in default of payment, and that security, whether it is a title deed, whether it is a logbook, or whichever document that was used to secure these debts, when they realize it is threatened, that it may not be able to pay off the amount that they had been advanced, including the interest accrued on it, then they may petition for the company to be wound up so that they receive their money. So you note that receivership is normally after a creditor, and it's a secured creditor who will appoint a receiver to ensure that they're able to recover the funds given to that company. Administration, on the other hand, is where a company is struggling financially or is already trading insolvently, but it may be able to be saved. It's not, there's hope literally. And this is normally voluntary. It's where the directors will agree to appoint someone to oversee the saving of that company, and an administrator will investigate the company's affairs, compile a report that will address the current status, including the financial circumstances, the past management, and while they may be appointed by the directors, they also need to report to the creditors, because the creditors are at risk of their money is not being paid to them. We talk about liquidation. Liquidation signals the end of a company's trading. It can no longer transact. It can no longer enter into contracts. It can no longer buy assets. It cannot, if it was meant to, it was formed probably to buy and sell land, to build apartments, then it can no longer do that. And once the liquidation is done, is where now dissolution comes in. And dissolution is that it no longer exists. The share certificate, the incorporation, that certificate will be withdrawn and it ceases to exist. So we have these 4 terms, and their differences are in who brings what action, how will that be done. We'll see how receivership will be done, how liquidation will be done, and whether the aspect of, is it voluntary or is it sanctioned by the court? Did the shareholders and the directors agree that we need to finish the business that we started with this company? We started with the formation of a company, its directors, its shareholders, how to get financing. So we'll agree whether it is voluntary or the aspect of it being voluntary has been bypassed by events. It's no longer in your control. Now you can no longer act. It's not up to you. Outside forces will dictate what happens to this company of yours. So you remember that winding up precedes its dissolution. So you first need to initiate the winding up proceedings. Once the winding up proceedings have been done, then now it can be dissolved. Winding up will mean the assets will be distributed, the creditors need to be paid off, the statutory deductions need to be paid, and once the books of accounts have been closed, then the company can be dissolved. And prior to dissolution and after winding up, the legal entity of the company remains and can be sued in a court of law. We said that it's in winding up that that company stops existing. But no, it is in dissolution that the company stops existing. So once you wind it up and prior to it being dissolved, its legal entity remains. It is still a separate entity. It is still recognized by law. Once it is dissolved, then the law no longer applies it. The law no longer recognizes it. And this element of it can be sued, it can sue in its own name, now ceases to exist. We look at the modes or types of winding up, and we are guided by Section 212 of the Companies Act. So it can either be voluntary or it can be supervisory or it can be compulsory, where it is the court that now guides the process. It's the court that now decides what will be done to this company. This is Part 6 of the Companies Act that provides the modes of winding up. This is Section 12, and it's either the court, which is what we've said is compulsory, it is voluntary, or it is supervisory. And the provisions of the law will be followed. And Section 2 provides that unless the contrary appears, these are the only modes of winding up that we have. So we are guided by the Companies Act, Section 212, Part 1 and Part 2 on the same. Section 213 provides for the contributories as well as section and the liabilities, whereby we have, when it's the winding up by the court, the High Court shall have the original jurisdiction. Section 219 will provide the circumstances in which the company may be wound up by the court. It can be done by the members or creditors of the company without interference of the court. And the grounds are provided under Section 271, whereby you first pass a special resolution to wind it up voluntarily. And the reason for this may be, one, there is loss of business. If the company, the directors, the shareholders feel it is no longer profitable to operate, it is no longer profitable to continue carrying on this business, they can pass a resolution and wind up that company. Instead of waiting for it to make losses and be declared bankrupt, they can actually preempt, where they look at the books of accounts, they realize the future may not look very bright for them. So they preempt that essence of having outsiders decide for them. They do it for themselves. And we're also the members may wish to distribute their surplus assets amongst themselves and terminate the company's activities. If the members feel we have reached where we wanted, we don't see any other profit, or we don't see any growth that we may have, so let us just finish up this business. Whatever assets we have gained, let us distribute. We can sell off, then distribute the surplus amongst ourselves. We don't need to continue. There's no motivation for us to continue doing this. It also happens where there's a breakdown in management. There are angles every now and then. So they decide, let us pass a resolution, cut short this activity that we are currently doing. And we wind up, we save ourselves future headaches of taking each other to court, where we have our creditors taking us to court because we are not able to make decisions. We are basically not agreeing. So that is a members' voluntary winding up. It is also voluntary, whereby if the company was formed to last only for a fixed period and that period has come to an end. Let's say you formed a company to speculate, where we buy land in these remote areas. We are saying probably the expressway will pass through the land. We have the SGR. You form a company for a specific reason, and the SGR passes through, or it's rerouted, and you sit down and realize we have no business being in operation. Let us wind up because either the event didn't happen or the event happened, and we have recouped our investment. We are able to move on from here and do better, or just move our separate ways. And this is where we are saying that if that you are doing that for a specified event, and we have instances where a founding company director is on, and the members feel there's no guidance, there's no glue that holds us together, they may decide to wrap up that company, to wrap things up and move on from there. And that is a members' voluntary winding up, where these members themselves conduct the liquidation process through the appointed liquidator. And this is only possible where the company is solvent, unable to pay its liabilities in full. You must be able to pay off all your creditors. You must be able to pay the costs of winding up. You must be able to pay up your liquidator. And the directors at the meeting must declare that the company is solvent. And if it has debts, within 12 months from the commencement of these winding up proceedings, it must be able to pay them off, or the debts. So there's no credit coming to stop this process and say that, no, you can't wind up because you owe me money. And this declaration must be made within 30 days, preceding the date of passing of the winding up resolution. Again, you deliver it to the registrar, signed by a copy of the report of auditors, and the profit and loss prepared. The profit and loss is what will guide the registrar to confirm your status. Are you solvent? Are you able to pay off your debts? Are you able to pay off any costs that originate from this resolution you're passing? Will the liquidator be properly compensated or remunerated for the job that he is doing? And where these directors make a false declaration of solvency, then the Act provides they may be imprisoned or a fine at the discretion of the court. And the directors, the ones to be held liable, because it is at that meeting where the special resolution will be held. They provide the declaration. We are doing well enough to pay off debts. We are doing well enough to cover the costs, that within 12 months, we'll have cleared all assets, we'll have sold, settled our debts, and we will have the surplus with us.